Hello dear learners. Today we will be dealing with one of the important doctrines which is known as Doctrine of Laches. After going through this e-content module, we shall be able to understand the meaning and the concept of Doctrine of Laches, historical evolution of Doctrine of Laches. We will try to understand the purpose of this doctrine and the judicial approach in dealing with the cases involving laches. Doctrine of laches is based upon the maxim, which means that equity aids the vigilant and not the one who slumber on their rights. It's well settled under Article 226 of Indian Constitution. The power of High Court to issue an appropriate writ is discretionary on the grounds for refusing the relief under Article 226 of the Indian Constitution is that the petitioner is found guilty of delay. And laches, it's imperative that if a petitioner wants to invoke the extraordinary remedy available under Article 226 of the Constitution, then the petitioner should approach the court with an earliest reasonable opportunity. Inordinate delay for making the motion for a writ will be a good ground for refusing to exercise the discretion. It's essential that the person who are aggrieved by the orders of the government or by any executive action should approach the courts with utmost promptness. In an appropriate case, the High Court may not exercise its discretion to grant and may refuse to grant relief if there is such a negligence or omission on the part of the applicant to assert his right, taken in conjunction with the lapse of time and other circumstances, as causes prejudice to the other party. In legal context, laches signifies the opportunity of asserting or claiming the right is lost because of unreasonable delay to avert the claim. The doctrine of laches is often used in civil and tortious cases where the defendants invoke the said doctrine as an affirmative defense in equity to dismiss the petition filed by the petitioner at the threshold, alleging that the petitioner approached the court beyond reasonable time period. The doctrine is based on the Latin maxim, which means that equity aids the vigilant and not the one who slumber on their rights. It simply means that legal right or the claim proposed by the petitioner will not be allowed or enforced if there is a long delay in asserting the right or claim. Now, a question may arise in your mind as to what is the aim, or you can say the purpose of Doctrine of Laches. The underlying objective of Doctrine of Laches is that the courts do not encourage agitation of state claims and exhuming matters which have already been disposed of or where the rights of third parties have accrued in the meantime or where there is no reasonable explanation for the delay. Where there is inordinate delay in filing the writ petition, the courts under Article 32 or 226 of the Constitution of India may refuse to exercise its discretionary powers. The fact that the third party rights were not created is hardly a ground for interference. This principle applies to orders which are void, and this was observed in the case of State of Rajasthan versus Lakshmi in year 1996. I quote, "Though the order may be void, if the party does not approach the court within reasonable time, which is always a question of fact, and have the order invalidated or waived, the discretion of the courts has to be exercised in a reasonable manner. When the discretion has been conferred on the court may, in appropriate case, decline to grant the relief even if it holds that the order is void, unquote. In another case titled Rabindra versus Union of India 1970, in most instances, the Supreme Court observed that delay in filing a petition has the effect of preventing the opposite party from putting fair defense. This happens because during the course of time, witnesses go their ways, evidence disappears, memories fade away. Thus, the outcome is that it prejudices the position of an adverse party. And as a result, a defendant, by invoking this doctrine, puts a defense for himself and shifts the burden of proof upon the petitioner. Now we will be limelighting the historical evolution of this doctrine. Historically, this doctrine was developed in the Lord Chancellor's Court, where the plaintiff in equity delayed to file a petition within the reasonable time. Consequently, the relief was denied on the ground of Laches, even though no specific prejudice to the defendant was cast. The application of this doctrine dates back in centuries when the kings applied this doctrine to administer their kingdoms, precisely not under this umbrella term, but rather holding standard-like approach. The Bible records one such illustration of Solomon's wisdom, where he resolved the well-known maternity dispute between the two women, claiming to be the mothers and praying for the custody of child. And one of the mother consents to barbaric suggestion, and the other chose to lose the custody rather than to see her child killed. Solomon awards the custody of later by applying the wisdom that the child would be safer with that woman. Also, the administration applied the theory considering interest publicae, which means that it is in the interest of society as a whole that there is an end to litigation. It signifies that all litigation should come to an end to provide immediate justice to all. Now we will move to certain essential requisites for application of Laches. For applicability of the doctrine of Laches, certain essentials must be satisfied to bar the petitioners from litigation. Number one, knowledge of the claim by the petitioners beforehand. Number two, unreasonable delay in bringing the petition. Number three, negligence to assert a claim. And if these conditions are met with, it will disentitle the party to relief. The doctrine of Laches prevents the proprietor from taking undue advantage of law by delaying the institution of a petition. Now we will move to another aspect which is involved in the doctrine of Laches, that is the difference between doctrine of limitation and Laches. Period of limitation and Laches appear to be same. However, these are surely different in a number of ways. Like, law of limitation is concerned with the statutory time period which is lost. It is mandatory and needs to be strictly adhered to. It's also rule-governed behavior and involves easily ascertainable facts. In law of limitation, the rules are already codified and therefore it is simple in administration. When we talk about doctrine of Laches, on the other hand, is concerned with the reasonableness of delay in filing a legal action. It is case specific and solely depends on the discretion of the judges to assess and decide as to whether the delay was just or malicious. It follows a standard-like approach and considers broad range to the facts. It involves complexity in attaining justice to administration. For successfully claiming Laches as a defense, the defendant must prove that his status has been changed because of the unreasonable delay in filing the petition caused to him to be in a worse position, and the delay in claim resulted in number 1, potential award of damages being larger, number 2, property plaintiff seeks to resource has been sold, witness testimony or evidence no longer is available, or during the course of time plaintiff lost all the money and the assets and is not in a position to repay. However, the delay which have caused no harm to the other party of the proceedings and may not be considered unreasonable delay, and the defendants could not escape from the said doctrine. Now, we will be limelighting the role of judiciary in dealing with the cases which involved Laches, which involved delay. Laches and limitations are important factors to be considered in the exercise of discretionary relief under Article 32 of Indian Constitution. In context of Laches vis-a-vis writ petitions under Article 32, the relevant question which might arise for considerations are whether any time limit can be imposed by the Supreme Court on the petitions filed under Article 32 of Indian Constitution. Secondly, whether Supreme Court would apply the provisions contained in Indian Limitation Act in accordance to the facts or any other limit. This issue came up for judicial scrutiny for the first time in the case of Tilok Chand Moti Chand versus H.B. Munshi in year 1969. In this particular case, the assistant collector of sales tax gave a refund of certain amount of sales tax paid by the petitioner with the direction that the refund should be passed on to the customers and receipts be produced before the office. The petitioner, however, didn't fulfill the condition, and consequently the amount was forfeited to the state under Article 21 Class 4 of Bombay Sales Tax Act 1953. The petitioners challenged the order of forfeiture under Article 226 of the Constitution on the basis that forfeiture was without the authority and violated the fundamental rights of the petitioners. However, the petitioner did not take the matter in appeal to Supreme Court. However, the Supreme Court opined in Kantilal, Babul and Brothers versus H.C. Patel, the validity of Section 21 Class 4 of Bombay Sales Tax 1953 was put into jeopardy, and was held that the section did not lay down any procedure for ascertaining whether in fact the dealer concerned had collected any amount from the purchasers. And after coming to know about this, the petitioner of Tilok Chand case, in the wake of the concerned law being declared unconstitutional, in 1968 filed a writ petition under Article 32 for quashing the order of forfeiture, which was passed in year 1958. The main issue before the Supreme Court in the case was whether any period of limitation could be specified for petitioners under Article 32. The court by majority rejected the petition. However, the issue resulted in sharp difference of opinion among the judges who constituted the bench. Chief Justice Hidayatullah observed, the question is one of the discretion for this court to follow from case to case. There is no lower limit and there is no upper limit. A case may be brought within the Limitation Act by reason of some article, but this court need not necessarily give the total time to the litigant to move to this court. Similarly, in a suitable case, the court may entertain such a petition even after the lapse of time. It all depends upon what the breach of fundamental right and the remedy claimed are and when and how the delay arose. In brief, the Supreme Court observed that the Supreme Courts and the High Courts should not deny relief under Article 32 and 226 of Indian Constitution by applying the statute of limitation. The Constitution should adapt a flexible approach and examine the facts of each of the case to see if laches could disqualify the claim or not. In his verse, I quote, "In a suitable case, the Constitution may entertain a petition even after lapse of time, but it will all depend on the breach of fundamental right and remedy claimed and how the delay arose." Unquote. In the present case, Chief Justice Hidayatullah felt that the petitioners were guilty of laches which disentitled them relief. There existed no question of mistake of law on the part of petitioner, whereas they should not be allowed to take advantage of later Supreme Court's decision, which is favorable to them. Article 32 guarantees the right to approach the court, but that does not restrict the court's decision to grant relief. One of the considerations relevant for exercise of the discretion is laches. In one of the cases titled Ravindra Jain versus Union of India, the Supreme Court held that on the grounds of unreasonable delay, the remedy under Article 32 can be denied. Moreover, there has been no case to overrule the earlier judgment. We observe that on one hand, the writ petitions filed within the limitation prescribed for civil actions for the same may be dismissed on the ground of delay and laches, and on the other hand, the court may entertain a petition even after period of limitation. The Supreme Court in P.S. Sadasiva Swamy versus State of Tamil Nadu in year 1975 observed that it is not that there is any period of limitation for the courts to exercise the powers under Article 226, nor is it that there can never be a case where the courts cannot interfere in the matter after the passage of certain length of time, but it would be a sound and wise exercise of discretion for the courts to refuse to exercise their extraordinary powers under Article 226 in the case of persons who do not approach it expeditiously for the relief and who stand by and allow things to happen and then approach to courts to put forward the state claims and try to unsettle the settled matters. Supreme Court in the case of Arun Kumar versus SE Railways 1985 held that when an applicant had made a representation against the seniority list to the administration in year 1967, which was replied in year 1973, there is no inordinate delay in filing the writ petition, in view of the fact that the railway administration was itself guilty of delay. Likewise, a delay of 4 years was ignored by Karnataka High Court in view of serious adverse consequences to the petitioner. But on the other hand, an unexplained delay of 2 years after the completion of acquisition process was found fatal for the maintainability of writ petition. In Keshav Pal versus State of Bihar, decided in year 1985, again even a delay of few days was considered fatal because it upset the admission of others. In yet another case, the Supreme Court ruled that the challenge to the appointment of principal after a period of 9 years on the ground that he did not fulfill the requisite qualification. Dear learners, if we attempt to analyze the doctrine, prima facie appears to be an easy defense for the defendants to raise in order to escape their liability from any charges or allegations which are raised against them. But the uncertainty it encompasses by vesting too much of power in the hands of court creates skepticism about its productivity. The inherent features of this doctrine relies heavily upon the wisdom and good faith of trial judge. It's not difficult to see how discretionary errors might happen in application of laches. If the law requires the judge to determine in equity whether a plaintiff's delay in bringing the petition was unreasonable, undeniably there will be conflict of opinions as to constitute unreasonable delay. Should a person with devitalizing chronic illness but a sound mind be excused for failure to bring a petition? Or should a person which has been misled by third party into believing that he had no cause of action be allowed when he finally comes to file a petition? Or would the delay be considered as unreasonable? The possibility of such issues arising and incorrectly being decided is what must be looked into, because at times when judicial wisdom and good faith fail us, which they sometimes do, highly discretionary laches fail us too. Nevertheless, in its working, it is often observed that laches approach victory to the administrators, but not necessarily for the communities. Dear learners, if we try to conclude today's deliberations, it's accepted without doubt that the doctrine of laches has played a pivotal role in maintaining equity in the judicial system by crusading for vigilance and reprimanding those who have not complied with the same. However, the laches of awareness and education pertaining to exercise of legal rights in India poses threat to the theoretical application of laches in law. Nevertheless, the application of this doctrine by numerous judges in numerous cases has shaped and built the principles of this doctrine to suit the contemporary needs, keeping the gnosis that we keep today's in mind. When looked in the light of constitutional rights, it's important to reiterate the fact that no time limit can be set on the wrongs done against the constitutional rights, as these are values and principles on which the entire nation is based. On limiting these wrongs based on time would simply set a wrong precedent, with many wrongs being committed and done away with. Thus, the application of laches also act as a filter, as courts are often flooded with frivolous cases. The ability of the authorities to give due consideration to those cases that hold substantive value can be hampered, interfering with the principle of equity. Once again, it would thus be safe to say that the doctrine of laches is a watchdog of justice in a legal system. which ensures that only the right cases are addressed and any malice or unequited delay is properly dealt with due reprimand. Therefore, it can be concluded that doctrine of Laches throughout the years of its evolution has eased tracing the burden of proof on the plaintiff, simplifying the process of accessing his or her intent in the entire process, giving a clearer picture of the case that is to be dealt with. A question of delay or laches is a question which must be considered by the writ court more so when the order is legally sustainable. The doctrine of laches is an equity doctrine and can be applied in a flexible manner to suit the requirements of each case for justice. With this, we conclude today's lecture. Thank you very much.